Hello everyone. In the last presentation, we have seen that when the death is caused by doing an act with an intention of causing death, with an intention of causing bodily injury which the accused knows is likely to cause the death of the victim, or with the intention of causing bodily injury and the injury so inflicted is sufficient in the ordinary course of nature to cause death, or with the knowledge that the act is so imminently dangerous that death or bodily injury likely to cause death would be the most probable result of the act, and the act is done without any justification or excuse, it is murder. Even where the case falls under one of the conditions specified under Section 300, a person will still be liable only for culpable homicide not amounting to murder if he can bring his case within one of the five exceptions provided under Section 300. These exceptions will be explained in this presentation. Section 300 provides five exceptions, and if the case is brought under any of them, the offender would be liable not for murder but only for culpable homicide not amounting to murder. What are these exceptions? Under exception 1 to section 300, causing death under grave and sudden provocation is not murder but only culpable homicide not amounting to murder. In order to bring the case under exception 1 to section 300, it has to be shown that the offender was provoked by the person whose death was caused. The provocation was grave and sudden enough to cause loss of self-control. The offender, while deprived of the power of self-control due to such grave and sudden provocation, caused the death of the person who gave the provocation. Even where he caused the death of any person other than the person who gave provocation by mistake or accident, he would be liable not for murder but only for culpable homicide not amounting to murder, because such a situation is also covered under the exception. This exception is again subject to certain provisos. According to the first proviso, provocation should not be sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. For example, where A goes to B's house and abuses B and insults him before his family, which provokes B, and he pushes A out of B's house, abusing him. A immediately takes out a knife and stabs B thrice, causing his death. When prosecuted for murder, A cannot plead that his case falls under exception 1 to section 300 because here A voluntarily provokes B as an excuse for killing him. According to the second proviso, provocation should not be given by anything done in obedience to law or by a public servant in the lawful exercise of the powers of such public servant. For example, where A police officer, is arresting X on a warrant for theft alleged to have been committed by X. B, X's brother, obstructs A and attempts to prevent the arrest. A pushes B aside, and at this, X attacks the police officer, causing his death. X cannot plead that his case falls within the exception. According to the third proviso, provocation should not be given by anything done in the lawful exercise of the right of private defense. For example, where A is molesting B and C, B's father, attempts to stop him by slapping him and pushing him aside. A pulls out a knife and stabs him, causing his death. Here, C was exercising his right to defend his daughter. Therefore, his act cannot amount to provocation to bring A's case within exception 1 to section 300. Whether the provocation was grave and sudden enough to prevent the offense from amounting to murder is a question of fact. The test would be whether a reasonable man belonging to the same class of society as the accused, placed in the situation in which the accused was placed, would be so provoked as to lose his self-control. The provocation may be caused by words or gestures. The mental background created by the previous acts of the victim can also be taken into consideration for ascertaining whether the subsequent act caused grave and sudden provocation for committing the offense. The fatal blow has to be traced to the influence of passion arising from that provocation and not after the passion cooled down by lapse of time or otherwise giving scope for prior planning. Let us take the case of K.M. Nanavati versus State of Maharashtra to understand the scope of this exception. In this case, Nanavati, a naval officer, is alleged to have killed his wife's paramour Ahuja, who was a friend of Nanavati. The wife of Nanavati confessed to him that she had illicit relationship with his friend Ahuja, and when she confessed, Ahuja was not present. Nanavati then drove his wife and children to a cinema, left them there, went to his ship, took a revolver on a false pretext, loaded it with 6 rounds, did some official work there, and then drove to Ahuja's place and shot him dead. He then surrendered himself to the police. When he was prosecuted for murder, his defense was that when he shot the deceased, he was deprived of the power of self control caused by sudden and grave provocation. The Sessions Court referred the matter to the High Court of Bombay, which held him liable for murder under Section 302. He appealed to the Supreme Court. Under Exception 1 to Section 300, culpable homicide is not murder if the following conditions are complied with. 1. The deceased must have provoked the accused. 2. The provocation must be grave as well as sudden. 3. The offender, by reason of the said provocation, must have been deprived of his power of self-control. 4. He should have killed the deceased during the continuation of the deprivation of his power of self-control. And 5. The offender must have caused the death of the person who gave the provocation or that of any other person by mistake or accident. The question before the court was whether a reasonable person placed in the same position as the accused would have reacted to the confession by his wife in the manner as the accused did. The Supreme Court held that between 1:30 p.m. when he left his house and 4:20 p.m. when the murder took place, 3 hours lapsed, and hence there was sufficient time to regain his self-control. Further, his conduct clearly shows that the murder was a deliberate one, and even if there was exchange of abuses between the parties before the accused shot the deceased, it cannot be taken as provocation sufficiently grave and sudden to attract Exception 1 to Section 300. The appeal of the accused was therefore dismissed. Coming to the second exception to Section 300, under this exception, causing death exceeding the right of private defense is not murder but only culpable homicide, not amounting to murder, if the offender is exercising the right of private defense of person or property. He, in good faith, that is, after exercising proper care and attention, believes that he has the right in the given situation. He exceeds the power given to him by law and causes the death of the person against whom he is exercising such right of private defense. There was no premeditation and there was no intention of doing more harm than is necessary for the purpose of such defense. Thus, in order to bring a case under this exception, it has to be shown that the accused was exercising his right of private defense and while doing so exceeded the power given to him by law and caused death. It has also to be shown that he believed, not recklessly but after exercising proper care and attention, that he had such right and that he had no intention of causing more harm than necessary for defending himself or any other person or for defending his or any other person's property. It should also be proved that there was no premeditation or prior plan. As an example, let us take the case of Lakshmi Koeri versus State of Bihar. Here, the accused was suspected of having committed theft in dwelling house, punishable under Section 380 and Section 457 IPC. A Havaldar H and a constable were deputed to arrest him. They saw the accused coming out of a toddy shop and chased him, and the accused ran. H managed to catch him and there was a scuffle between them. The accused took a short knife from his waist and gave a blow with it on H's arm. He fell in a nala and the accused entered the nala, gave several blows to H, got out of the nala and then fled. H was brought to the hospital where he died. When prosecuted for murder, the question was whether the accused had a right of private defense against H, a public servant, and did it go to the extent of causing the death of the accused. H was not in his uniform, and therefore the accused had no possibility of knowing that H was a public servant and hence had a right to defend himself in the scuffle with H. But there was no fear of any grievous hurt or death to the accused from H, and hence he had no right to cause the death of the assailant and thus exceeded his right of private defense. In addition, when H fell in the Nala and was helpless, the accused fell on him and gave a number of blows with the knife, causing a number of incised wounds. In the facts and circumstances of the case, the court held that though initially the accused had a right of private defense, the case does not come under exception 2 to section 300, as his right did not extend to causing the death and he intentionally inflicted more harm than necessary for defending himself. The trial court held him liable for murder, and the same was conferred by the Patna High Court. Under the next exception, that is exception 3, culpable homicide is not murder if the offender, being a public servant or aiding a public servant acting for the advancement of public justice, exceeds the powers given to him by law and causes death by doing an act which he believes in good faith is lawful and necessary for the due discharge of his duty as such public servant, and he does the act without ill will towards the person whose death is caused. Here, it has to be shown that the accused is a public servant discharging his duty as such, or a person who is assisting a public servant who is acting for the advancement of public justice, and he had exceeded the powers given to him by law for the purpose and did the act which caused the death of the person. It must be shown that the accused had believed in good faith that it was lawful for him to act in such manner and it was necessary for the proper discharge of his duty as such public servant. It should also be shown that the accused had no ill will towards the person who died. Dukhi Singh versus State of UP is an example wherein the scope of this exception has been explained. In this case, the accused, a constable of Railway Protection Force, shot a thief suspected to be tampering with sugar bags from goods wagon on the order of a havaldar in discharge of his duty. But the shot hit a fireman and caused his death. He was prosecuted for the murder of the fireman, and the trial court convicted him for murder under section 302 IPC. An appeal was preferred in the Allahabad High Court. Section 46 of the Criminal Procedure Code lays down that when a police officer arrests a person and such a person forcibly resists the endeavor to arrest him or attempts to evade the arrest, such police officer may use all means necessary to effect arrest, but this does not give him a right to cause the death of the person unless he is accused of an offence punishable with death or imprisonment for life. It was held that the case would be covered by exception 3 to section 300 of IPC. The said exception provides that culpable homicide is not murder if the offender, being a public servant or aiding a public servant, exceeds the power given to him by law and causes death by doing an act which he in good faith thinks to be lawful and necessary for the due discharge of his duty as a public servant, and there is no ill will towards the person whose death he has caused. In the present case, there was no ill will between the accused and the deceased. The accused was a public servant and his object was the advancement of public justice. He caused the death of the fireman by accident while doing an act which he in good faith believed to be lawful and necessary for the due discharge of his duty, but exceeded the power because the deceased was alleged of committing theft, which is not punishable with death or imprisonment for life. In such circumstances, it was held that the offence committed was culpable homicide, not amounting to murder, punishable under Section 304, Part 2 IPC, and not murder. The conviction under Section 302 was set aside by the High Court. Now, coming to the next exception, Exception 4 to Section 300, culpable homicide is not murder if death is caused in a sudden fight. There must be heat of passion upon a sudden quarrel. The act must have been committed without premeditation, and the offender should not have taken undue advantage or acted in a cruel and unusual manner. Here, it has to be shown that there was a sudden fight which was of such a nature as to cause heat of passion among the parties. The act which caused death must have been committed under such heat of passion, and there should not be any prior plan or premeditation to assault or cause the death of the deceased. It must also be shown that the offender did not act in an unusual and cruel manner and had not taken undue advantage of the situation. In such cases, it is immaterial as to which party offers the provocation or commits the first assault. Let us take a case under this exception, Surinder Kumar versus Union Territory of Chandigarh. In this case, the accused had an argument with the deceased's brother in the presence of the deceased and the sister of the accused. The deceased brother was showering filthy abuses in their presence, and the deceased did not stop him from doing so. At this, the accused got enraged, went into the kitchen, brought a knife, and inflicted a blow on the neck of the deceased brother. The deceased, who was trying to stop him, was assaulted, and 3 blows were inflicted, one on the shoulder, one on the elbow, and one on the chest, because of which he collapsed and later died while on his way to the hospital. The accused was tried for murder, and the trial court convicted him for murder under Section 302. In appeal, taking into consideration the fact that there was no ill will between the accused and the deceased, and that injuries were inflicted in a sudden fight due to heat of passion, the High Court held that the accused was entitled to the benefit of Exception 4 to Section 300 IPC, and therefore convicted him under Section 304 instead of Section 302 IPC. Now, coming to the last exception under Section 300, culpable homicide is not murder when the person whose death is caused is above the age of 18 years and he suffers death or takes the risk of death with his own consent. Dashrath Paswan versus State of Bihar is a case which falls under this exception. In this case, the accused was a student of 10th class. He failed in the annual examination for 3 years in succession and was very much upset at these failures and decided to end his life. He informed his wife, who was a major and illiterate, about this. She asked him to kill her first and then kill himself because she did not want to live without him. He killed her, and before he could kill himself, he was arrested and prosecuted for murder of his wife. The trial court convicted him under Section 302 IPC for murder. He appealed. The question before the High Court was whether the case falls under Exception 5 of Section 300, since the age of the deceased was above 18 years and she consented to suffer the death. The prosecution contended that consent was not free consent because it was given under pressure of the prospect of widowhood. The High Court rejected this contention and held that it cannot be accepted that the deceased gave her consent under fear of injury or under misconception of fact, which will be invalid under Section 90 Indian Penal Code. The conviction of the appellant was accordingly altered from murder under Section 302 IPC to culpable homicide not amounting to murder under Section 304 Part 1 IPC. Thus, even where a person causes death with the intention or knowledge specified under Section 300, if he can bring his case under any one of the exceptions provided under Section 300, he would be liable not for murder but only for culpable homicide not amounting to murder, punishable under Section 304 Indian Penal Code. Now, before winding up, let us see the changes made pertaining to these provisions in the new penal law, that is, Bharatiya Nyaya Samhita 2023, which has not yet come into force. Chapter 6 of the Samhita, from sections 100 to 146, deals with offences affecting human body. Of these, sections 100 to 113 deal with offences affecting life. Section 100 deals with culpable homicide. The content is the same as that of Section 299 IPC, including the explanations and illustrations attached to the section. Section 101 deals with murder, the content of which is the same as Section 300 IPC, including the provisos to the section, exceptions, and illustrations attached to the section as well as the exceptions. Section 103 is equivalent to Section 302 of the Indian Penal Code. In addition to providing punishment for murder, which is the same as provided under Section 302, one more aspect has been added under subsection 2 to Section 103, according to which each member of a group of 5 or more persons shall be punished with death or imprisonment for life and fine if the group acting in concert commits murder on the ground of race, caste or community, sex, place of birth, language, personal belief, or any other ground. The punishment for culpable homicide not amounting to murder is provided under section 105 of the Samhita, which is verbatim the same as contained under section 304 part 1 and part 2 of the Indian Penal Code. Thank you.